Paranawe, Paranawe, Parana, Paranawe, Paranawe, Parana, Paranawe, Paranawe, Parana, hey, hey, Paranawe, Paranawe, Parana. Those of you who might have seen or experienced for yourself the Afro-Brazilian dance known as capoeira know that the song I just started us with is integral to the performance and to the ritual. There are many debates about the origin of the song, but many agree it's a song of freedom, of passage. It tells us the river is the way to freedom, the way to justice, the way to making a way when there ain't no way. And today we gather to talk about how we find our way forward. Good morning, good morning. My name is H. Adam Harris, and I want to welcome you to the 13th Annual Supreme Court Term and Review Conversation, hosted by the University of California Irvine School of Law and Ms. Magazine, moderated by Chancellor's Professor Michele Goodwin. Please welcome Professor Goodwin and her esteemed guests to the stage. What a pleasure to see each of you in person here at the Irvine Barclay Theatre, and I'm sending an additional hello to those of you watching via live stream. One housekeeping thing for those of you here, please take a moment to silence your cell phones. And now a special treat, please welcome to the stage the Dean of the University of California Irvine School of Law, Mr. Austin Parrish.
That's the first time meeting with the dean has been considered a treat. But on behalf of the faculty and staff of the University of California Irvine School of Law, it's my privilege to welcome you, both those in the Barclay Theatre and those watching online, to our 13th Annual Supreme Court Term and Review. I'm going to go off script. I understand that some of our incoming 1L students, which will be the class of 2026, are joining us either online today, and maybe a round of applause for their achievements for being admitted. When the law school was founded 14 years ago, it was built on the bold idea that the very best law schools are deeply committed to their communities and connected with them. The goal was to build an exceptional interdisciplinary institution, attracting the top faculty from around the United States and the world that would recruit the very best students to Orange County and provide them with an extraordinary education. As part of our efforts each year, the law school and our faculty host hundreds of speakers, leading scholars, judges, lawyers, journalists, policymakers, leaders of government, public interest organizations, and corporations who come to Irvine to talk about some of the most pressing issues of the day. One of the cornerstones of those efforts, and one of the largest attended events each year, has been this event, our long-standing annual Supreme Court Term and Review. I want to begin with a very big thank you to our sponsors, Ms. Magazine, and to TorkLaw. A particular special thank you to TorkLaw founder, Reza Torksada, who has been such a long-time supporter and a cheerleader for our school and for our students. And also thanks to Leslie Dodd, our event manager, and to the Barclay Theatre for the tremendous work behind the scenes. How about a round of applause? My role today, though, is a little different. Each year, a faculty member of our law school heads up and oversees our Supreme Court Term and Review. And over the last few years, our moderator today, Chancellor's Professor Michele Goodwin, has been responsible for this event, inviting speakers, organizing the details, moderating the panel. And as many of you know, Michele and her husband, Chancellor's Professor Greg Schaefer, are leaving UC Irvine for Washington, D.C., where they'll take their considerable talents. I heard some boos in the audience. As we end the academic year today, this formally will be Professor Goodwin's last formal event. When a faculty member retires, our tradition is to take a moment to reflect on an amazing career and to thank faculty members for all their contributions to a law school. Often when that occurs, we bestow a UCI law clock as a small symbol of our gratitude. Our faculty transform the lives of our students through the classes they teach, their mentorship, the programs and initiatives they run, and the work by which they advance their fields. The clock is designed to represent a token of appreciation for all the time dedicated and contributions made to making our school the fabulous public institution it is. This is a common tradition when faculty retire. A dean, however, has the power to recognize and bestow a clock upon other long-standing faculty who are not retiring, but whose contributions have left an indelible mark on our great institution. Earlier this year, we held an event honoring departing and retiring faculty. Professor Goodwin, however, was teaching at Harvard Law School, and planes and travel and other things meant she was unable to attend in person. So it's my great privilege this morning to be able to present on behalf of the University of California Irvine School of Law as a small token of our deep gratitude, a UCI law clock to Chancellor's Professor of Law, Michele Goodwin. Michele, if I could ask you to join me. Michele, your commitment to our students and to our school over the last decade has been extraordinary. The contributions you have made to research and scholarship, with your national and international leadership, and with your commentary on some of the most important pressing issues of the day, have been inspirational. While we're sad to see you and Greg moving to the other coast, we are eager to see all that you will continue to accomplish, and we know that your strong friendship with the law school and with Orange County will continue. Thank you for all you've done and for your many contributions to University of California Irvine School of Law.
Thank you so much.
Enjoy the event. Thank you so much.
This is a beautiful clock, and it's actually going to help us keep on time. Thank you, Dean.
They were just warning me that I was on camera because I was standing so close. And I really appreciated it, though, because I wanted to be close to that brilliance over there. I want to thank you, Professor Goodwin, for your many years of service and for your service to come. One of the things I love is that there's a persistence and an insistence in your work. And I think that that's a great reminder for us all as we go about our lives that hope is actually something that can be actionable. That it is a verb in many ways. It is not uncoupled from the reality of our lived experience, but it does require persistence and insistence. And that's kind of how we are able to make our way forward. So to kick us off, I thought I'd do a poem that reflects on hope. One Today by Richard Blanco. One sun rose on us today, kindled over our shores, peeking over the Smokies, greeting the faces of the Great Lakes, spreading a simple truth across the Great Plains, then charging across the Rockies, one light waking up rooftops, under each one a story told by our silent gestures moving behind windows. My face, your face, millions of faces in morning's mirrors, each one yawning to life, crescendoing into our day, pencil yellow school buses, the rhythm of traffic lights, fruit stands, apples, limes, and oranges arrayed like rainbows begging our praise. Silver trucks heavy with oil or paper, bricks or milk, teeming over highways alongside us on our way to clean tables, read ledgers, to save lives, to teach geometry, or to ring up groceries as my mother did for 20 years so I could write this poem. All of us, as vital as the one light we move through, the same light on blackboards with lessons for the day, equations to solve, history to question, or atoms imagined. The I have a dream we keep dreaming, or the impossible vocabulary of sorrow that won't explain the empty desks of 20 children marked absent today and forever. Many prayers, but one light breathing color into stained glass windows, life into the faces of bronze statues, warmth onto the steps of our museums and park benches as mothers watch children slide into their day. One ground, our ground, rooting us to every stalk of corn, every head of wheat sown by sweat and hands gleaning coal or planting windmills in deserts and hilltops that keep us warm, hands digging trenches, routing pipes and cables, hands as worn as my father's cutting sugarcane so my brother and I could have books and shoes. The dust of farms and deserts, cities and plains mingled by one wind, our breath. Breathe, Hear it through the day's gorgeous din of honking cabs, buses launching down avenues, the symphony of footsteps, guitars, and screeching subways, the unexpected songbird on your clothesline. Paranaway, Paranaway. Hear squeaky playground swings, trains whistling, or whispers across cafe tables. Hear the doors we open for each other all day, saying hello, shalom, buongiorno, howdy, namaste, or buenos dias in the language my mother taught me. In every language, spoken into one wind, carrying our lives without prejudice as these words break from my lips. One sky. Since the Appalachians and Sierras claim their majesty, and the Mississippi and the Colorado work their way to the sea, thank the work of our hands, weaving steel into bridges, finishing one more report for the boss on time, stitching another wound or uniform, the first brushstroke of a portrait, or the last floor of the Freedom Tower jutting into a sky that yields to our resilience. One sky towards which we sometimes lift our eyes, tired from work, some days guessing at the weather of our lives, some days giving thanks for a love that loves you back, sometimes praising a mother who knew how to give, or forgiving a father who couldn't give what you wanted. We head home through the gloss of rain or weight of snow or the plum blush of dusk, but always home, always under one sky, our sky, and always one moon like a silent drum tapping on every rooftop and every window of one country, all of us facing the stars. Hope, a constellation, waiting for us to map it, waiting for us to name it together. One today by Richard Blanco. Let's turn it over to the experts so they can name it our way forward.
Adam Harris, thank you so much. Let me start off by saying how much I love Orange County and you all. Thank you so much for being here. And for all of those who are tuning in online. In the times that we're in, a poem such as that could be banned in parts of our country. We know this. This is where we are now in our nation, where even Amanda Gorman's poem from President Biden's inauguration has now been banned in certain school districts. Before we begin, I want to thank Jerry Mandel, who operates and made possible the theater that we are in. Thank you, Jerry, and to the staff and team here. Leslie Dodds at UCI, who helped so much to bring this together, and Stephanie Wilner. And Shruti Kumar, who's been working with me. And I also want to do a land acknowledgement before we begin. And it's particularly relevant given the Supreme Court's term, but even beyond it. These are the land that the Tonga and the Atajiman preserved, such that we could be here. And I think that we can all appreciate what it means for people to preserve the things that then we come to occupy and enjoy. With that said, this wonderful audience, let's turn to these amazing guests that we have to help us unpack this year's Supreme Court term. And what a doozy. I mean, even this morning. And these folks are prepared people. You should have seen them behind the scenes on their cell phones, right? Getting the very last of the footnotes, right? They've been reading footnotes even. All right, it's been quite a term, so much for us to discuss in the brief time that we have together. And it really raises a question about even where do we begin? And perhaps we'll begin with the following. We're a year after the Supreme Court's decision in Dobbs. And this stage last year to a packed audience, and we got lots of people, thousands streaming in, who are joining us from around the country and the world. 50 years of a precedent had been overturned when the Supreme Court overturned Roe v. Wade and Planned Parenthood v. Casey. And in that decision, written by Justice Alito, the court said, well, if folks are unsatisfied with the court's ruling, they can take it to the polls, to the ballot boxes, right? They can go vote. And this was an interesting backdrop, considering where our country is with regard to voting. We know it's important, and certainly in the midterms, people showed up. But voting has not always been something that has been accessible to all people in our country, and we've even seen it this year with cases that were before the Supreme Court. So I want to start with voting rights, and I'm looking at you, Jamelle Bouie from the New York Times. Thank you so much for being with us. Tell us about Moore v. Harper, and then also, if you want to add in a little bit, and maybe Mario, I'll pitch to you, Allen v. Milligan.
Sure. So Moore v. Harper is the case out of North Carolina involving a highly gerrymandered federal congressional map. And the state Supreme Court said this map is so gerrymandered that it violates actually the North Carolina state constitution. So it's,
that says a whole lot.
Right. I'm from the South. I'm a Southerner. I have lots of affection
Where are
for
you from, the South?
I'm from Southern Virginia.
Okay, all right.
So basically from the North Carolina, like near the North Carolina border, I have a lot of affection for my brothers and sisters in North Carolina, but that is not necessarily a state where courts say, oh, this is so bad that you can't do it anymore. But this map, in fact, was so bad that they couldn't have it anymore, and so the court says we're going to do a new map for upcoming elections. The Republican legislature sues, essentially saying that, no, you don't have the right, you don't have jurisdiction to strike down this map. That under Article 1 of the Constitution, under the Elections Clause, it's state legislatures that have what they said was plenary authority to deal with federal congressional maps, deal with districting, deal with sort of elections. And the state Supreme Court has no say over what we want to do. Now, the Supreme Court heard this, in his opinion, Roberts essentially said this is just not the case, that the actions of state legislatures are bounded by state constitutions. Roberts, in his opinion, also leaves some wiggle room for the Supreme Court, saying basically that we are the final decision on the legality of, say, a congressional map, say some aspect of federal elections. But the point I want to make real quick is just the fundamental insanity of the claim being made by the North Carolina legislature, and by the claims being made by those who supported the North Carolina legislature in this dispute. One of the fundamental facts of the creation of the U.S. Constitution is that it was a response to the actions and behaviors of state legislatures. Prior to the 1787 convention, Madison writes what is kind of a screed about the actions of state legislatures, how they are making it impossible for the national government to exercise power, how they are overstepping their bounds, how they have rendered the Union essentially functionally unable to operate. And so much of the federal Constitution is written specifically to limit the authority of state legislatures. This is, in fact, was one of the causes for opposition to it, that you're taking away authority that properly belongs in state legislatures. And so to turn around and say, well, the Constitution thus gives this seemingly unlimited power to state legislatures to structure federal elections just doesn't make sense on its face.
So I want to turn to you, Mario, because I know this is a case also that you were following, and also Allen v. Milligan. I mean, these cases have racial implications, right? In fact, I almost thought it could have been my own Freudian slip when thought I heard you say, Confederate state, right? Because, I mean, look, let's just be clear, right? We could draw Venn diagrams, right, and see how these matters align. Race matters.
Right.
I mean, we can't pretend that it doesn't in a state like North.
You didn't read SFA.
I did, right?
Sorry,
I mean,
just checking. Okay.
check, please. Well, right. I mean, we're at a time where in Georgia, you can't give someone a cup of water or a sandwich if they're standing in line for 7 hours to vote. That's if they have the capacity to be able to stand.
Well, so race does matter, certainly in the voting context historically. Few or nobody should deny that, but if we add in Allen versus Milliken, race was the question in that case.
What
right?
was the question, Mario?
So we have Alabama, post-2020 census has to redraw districts. It has 7 districts. Prior to 2020, it had 1 sort of majority black voting district. But you have changes in the population in the 2020 census where the African-American population increases and suggests that in the redistricting or remapping that you would end up with a greater number of majority black districts. But because of the way the map is drawn, that doesn't happen, which causes the plaintiffs here to raise a challenge under Section 2 of the Voting Rights Act, which presents discrimination based on race or protected groups. And the question becomes, does Alabama have the authority or autonomy to draw the map in this way and to fail to create a larger number of black majority districts? And I will say, to me, this is actually the surprise of the term in some ways, because many people thought there was enough room for the court to interpreting the standard that's most relevant, a 1986 case called Thornburg versus, Jingles. Thornburg versus Jingles. I resist, it seems like lighthearted when it shouldn't be, right? The interesting thing in Alabama, maybe there are 2 interesting things, is the first would probably be that the district court in Alabama actually found in applying the standard from Jingles that the plaintiffs were correct, right? Which is that standard sort of says if you can prove that you are a large and compact minority group, that 2, you were politically cohesive, and 3, that your vote would be frustrated by the white majority, that you should have the right then to contest the drawing of the map. And why I thought it was the surprise is because with the new sort of conservative supermajority, I thought you could just interpret the case to determine that in applying Jingles that the state was fine in how it drew the map. And the state didn't put forth a really, I guess maybe Jamelle you can tell me if you agree. They didn't put forth a robust sort of explanation for how they had come to move.
Well, it's hard to justify
that. Put black citizens across. And their one claim about the maps that the plaintiffs offered that would have created multiple majority black districts was, oh, well, that will affect the contiguousness of the Gulf region, I guess was the, and so my sense was that you got Chief Justice Roberts and Justice Kavanaugh joining the sort of what we now might imagine is the more liberal minority of the court to suggest, and this is why I don't want to make it a larger decision than it is, that the district court in the way in which it applied the Jingles standard had applied it in a way that was defensible and that majority was not willing to overturn.
I want to open this up a little bit in terms of why this matters as well, right? Because we're talking about creating the kind of gerrymandered maps that really dispossess people from being able to elect officials that will represent them and their interest. I mean, that is it at the bottom line. Jessica, I see you nodding. Mark, you've joined in. You're nodding, Moira. So quickly, before we wrap on that, what would you like to add?
I just want to add, I think that Milligan is a paradigmatic case for this term, because what happened was Alabama got the new census numbers and said, oh yeah, we're going to gerrymander black people out of power. That's what we're going to do, because we see Brett Kavanaugh and Amy Coney Barrett and John Roberts on the Supreme Court. This is our moment, and we don't think that this court is going to enforce what remains of the Voting Rights Act. And they litigated this to the Supreme Court in an incredibly sloppy and arrogant way. Alabama's Attorney General put forth a truly bizarre argument that basically, if you read the Voting Rights Act to mean what it says, that it is unconstitutional because it is a violation of equal protection to simply look at race to decide whether a map is unfair. And I think that offended Roberts and Kavanaugh. And I think they said, we may be hacks, but we're not your hacks. I
went with, we may be crazy, but we're not that crazy.
Okay.
Whichever version, right?
But so this is exactly what happened in the case that Jamelle was describing, the independent state legislature case. This is what happened in the Indian Child Welfare Act case as well,
which
where
we're
you
going to
had
get to.
Sizable majorities looking at the way that in the Indian case, Texas, and in the North Carolina case, of course, Republicans in the legislature tried to put forth these cockamamie theories and barely bothered to do the homework, right? I mean, this was just ridiculous.
Don't you think that in part, if you look at the term last year, right? Again, we could just take Dobbs in the state of Mississippi. You know, just what an outlandish kind of suit to bring forward altogether. And if you can win in Dobbs, if you can win in Bruin, one after the other, on one hand saying that, a state that has legislation that's more than a century old, that doesn't matter. And then on the other hand, flipping it entirely, maybe bringing sloppy to the court, folks thought would be okay.
Right, but it turns out that the three justices who are sort of in the middle, still very conservative, but in the middle, Roberts, Barrett, and Kavanaugh, they have a very specific agenda. And
what
if
is
the
it?
case falls, well, so I think these are all creatures of the Reagan Revolution, right? Like John Roberts was in the Reagan Justice Department opposing the part of the Voting Rights Act that he just upheld, which is sort of weird performance art.
Shelby County v. Holder, right?
Yes. Barrett and Kavanaugh, very similar. And so I think when it comes to something like today's decision about, carving loopholes into civil rights laws and anti-gay discrimination, they're there. They're like, yes, this is my dream. All I want to do is let businesses discriminate against people I don't like. But when it comes to something...
Religious reasons.
Yes, that's right. When it comes to something like, just dismantling this really important law protecting Native children, or giving state legislatures absolute authority to rig elections, they're saying, we're not there yet. We will set the agenda. We were ready for Dobbs, we were ready for Bruin, but give us a couple years before you start assailing us with these big blockbuster decisions that we don't have the capital for right now.
Okay, well, that helps to set some of the term with just the first question. And let me just say to the audience, Erwin Chemerinsky wishes he could be here. Last night he called me at about 9 p.m. And we were going to try, I was going to try to do something special where you could hear the voice of Erwin. Seriously, we were going to try that, but unfortunately his laptop was left in a car. It was okay, but he tried. He tried. He really wanted to be here. Well, this kind of sets the stage for even thinking about today. And we're going to move around a bit. We are going to talk about the Indian child welfare case, but I want to talk about decisions from today. Right, this is how prepared these folks are. So 303 Creative, Moira, let me turn to you. What is that case? What is it about? And tell us about this 6-3 ruling.
So 303 Creative, it's a little bit of a rerun. It's very similar to a case that the court rejected about 5 years ago called Masterpiece Cake Shop. And the facts in 303 Creative are that a woman named Lori Smith living in Colorado says that she wants to expand her website design business, which she asserts is a creative business, get it, 303 Creative, that is expressive and customizable, and that she, because she is a religious conservative, believes that same-sex marriages are, to use her phrasing, false. And so she does not want to be compelled, as Colorado civil rights law would compel her to do, to treat same-sex couples seeking a wedding website the same way she would any other couple seeking that service. And in fact, she wants to be able to put a sign at the homepage of her web design business saying that she will not provide that service to people whose marriages she believes to be false.
Can I add one thing right here?
Yeah.
So, great setting of the case. One footnote that's important. No same-sex couple has ever asked Lori Smith to design a website for their wedding. And if you look at her webpage, you will understand why. Okay? Don't flatter yourself, Lori. We are not bursting through your door trying to hire you. But sorry, Moira.
Well, this is actually
That reminds me of the myth of Pristone.
Yeah.
Right, but go, okay. Mark Joseph Stern, Slate, Moira Donegan, The Guardian. Okay, all right, let's go.
well, this is actually a point of contention, Mark,
Right,
because Smith's legal team asserts that within 24 hours of her filing this lawsuit, she in fact did receive a request from a man named Stewart to create a website for his wedding to a man named Mark. They had, what was supposedly this man's request, along with his contact information. Melissa Gria Grant, who is a reporter at the New Republic, reached out to Stewart to ask him about his request. He had never heard of it. He had never made such a request. He lives in another state and is, in fact, married to a woman. So, you know, the veracity of that claim, you know, might be a bit dubious, but the Supreme Court, you know, sort of impervious to these facts and to Smith's lack of standing, granted cert on Smith's claim that following Colorado's civil rights non-discrimination ordinance that prohibited her from discriminating on the basis of identity in her public-facing business would violate her freedom of speech, right? She says, me making this website is, you know, a cry of my soul, and the Colorado civil rights law requires me to either speak in a way that I find false or to remain silent. And they found that she has a right to discriminate.
Her soul has a right to scream.
Yes. And you know, this is, you know, the facts of the case are kind of silly. As Mark pointed out, there's not really standing here. There's no real injury that has happened to this person, but the implications of 303 Creative, I think, are very chilling, not just to same-sex couples, but because the decision that was handed down, authored by Neil Gorsuch this morning, really has no limiting principle. It's kind of it's very imprecise in what kind of ability to discriminate it licenses. You know, it sort of collapses the distinction between speech and conduct, and it establishes this precedent that people who are, you know, using and engaging in the public market that the state helps maintain don't have to follow the state's rules that are designed to help, you know, create a pluralistic society. And it's also just like so like searingly insulting that she can put up this sign that says, I think this genre of person, this identity group matters less and they are offensive to me, and so I will refuse to engage with them as I would in any other matter in public.
So Mark, so one of the refrains that you hear people say, well, okay, well, why would anybody want to take business there? And so no harm, no foul, because no one would want to do business with someone like this woman.
Right, but of course this was a test case that was devised by a group called Alliance Defending Freedom that has been trying to get the Supreme Court to do exactly what it did this morning for many years. And so as Justice Sotomayor put it in her brilliant dissent, you know, there really is no clear limit. The majority says this only applies to expressive conduct, but what does that encompass? And she uses the real example of a funeral home in the South that would not hold a memorial service for a gay man because he was gay. And she says, is that expressive conduct? And I think the majority would say yes. And I think if you go even further, you can recast anything as expressive conduct, right? The guy behind the counter at Dairy Queen is suddenly an ice cream artist, right? And when he pours the swirl, he's expressing his love for the customer, right? It's a ridiculous idea. Jamelle, sorry.
No, and then Jessica, too. Well, Jamelle and then Jessica.
I wanted to really emphasize that point that anything can become expressive conduct, and let's use food service as another example, as a serious one. In fine dining, the dish is an artistic piece, right? It's a piece of art. It's consumed, but it's conceived as an aesthetic object that is expressing something that the chef is doing. So under 303 Creative, is it viable for the owner of a fine dining restaurant to put, I won't serve blacks because I don't want to express the opinion, essentially, that blacks are able to appreciate the things that I'm doing? Like, once you start to take it very seriously, and once you recognize, as Moira pointed out, this collapse of speech and conduct, anything
Where is the limiting
goes,
principle?
right.
And I want to add you into this, Jessica, too, because that also brings to mind individuals who may be perceived as having non-documented status. I mean, we saw this during a time during the Trump administration and even before, people who would think that they were going to be doing their own policing, right? If you looked at whatever that means, look non-documented, you can't come into this store, right? It brings added weight to the example that you just offered, right? My business is not for people who shouldn't be here. And what does that mean to belong in the first place? Jessica.
Justice Sotomayor, in her excellent dissent, also pointed out, why can't a website creator refuse to make a website for an interracial marriage on the grounds that she doesn't think that races should intermingle? how does the Supreme Court majority distinguish that context from a same-sex marriage? I read the opinion quickly, so I don't know if they addressed that analogy. I was a little worried during the oral argument that the Supreme Court might say something like rights to freedom against discrimination on the basis of sexual orientation are less weighty or less important than rights to freedom against race discrimination. I didn't see that in the opinion this morning. I hope I didn't miss it. So I'm glad at least that they didn't go there. I am a little worried about a comment in there that Justice Gorsuch said that if the same-sex couple were to prevail in this context, then it would lead to a situation in which anything that somehow implicates a protected trait could therefore be forbidden speech. And that worries me because marriage doesn't just implicate a protected trait. I mean, same-sex marriage is central to sexual orientation. Same-sex relationships are, and he seems to be missing that. More broadly, this opinion is very sterile and logical and formalistic, and for a justice who cares so much about religion, it very much lacks a soul, in my opinion.
Part of Atlanta Hotel just needed to suggest that the clerks there were engaging in expressive conduct when they discriminated on the basis of race, and then we wouldn't be able to uphold Title II. I mean, it's that kind of like...
But it also seems to me that part of what you're also surfacing, and this makes me think about the Mifepristone case, which is now Fifth Circuit. We're going to see what ends up happening. Judge Kaczmarek in Amarillo, Texas, allowed to go forward a case involving some doctors and a dentist who claim that Mifepristone, which is one of the drugs that's used in medication abortion, that for this drug to be on the marketplace, one, that it was rushed to the marketplace, that two, it's perhaps unsafe, even though it's been in the marketplace for 23 years, but that somehow the individuals who brought this claim, wanting it to be removed from the marketplace, had standing. The argument was that people who are harmed by abortion would come to see them and the dentist in order to have their health care addressed. And so the question that's come up is about judicial forum shopping. And I wonder if any of you want to speak to that and whether there was an element of this case that was also, I mean, it's not the same as the Mifepristone case in terms of the forum shopping for a judge, but still this very kind of broad latitude in terms of plaintiffs being able to have standing in cases where it seems that they really aren't harmed. Any of you want to jump in on that?
So, I mean, I just want to use that as the perfect example, right? Because this is an organization, Alliance for Hippocratic Medicine, that's basically not real, I think.
Right.
It's, you know, this group of...
It's created. It sounds fancy.
They incorporated in Amarillo, Texas, because there is one federal courthouse in Amarillo, Texas, and there is one federal judge who sits in that courthouse. And he is Matthew Kaczmarek, who before joining the bench devoted his entire life to opposing reproductive rights, including not only abortion but also contraception, who was put on the bench by Donald Trump specifically to hear these kind of suits and issue, as he did, a nationwide order purporting to ban Mifepristone in all 50 states, including states where it remains fully legal, and to force the FDA to withdraw it from the market. This is a guy who, in his opinion, rejected more than 100 scientific studies showing that this drug is safe, and instead cited anonymous blog posts on an anti-abortion website as proof that Mifepristone was deadly, and granted standing in part because he said that these doctors having to treat women who had incomplete abortions, that itself is an injury, because they so oppose abortion that having to actually deal with these patients,
having to treat a patient as a doctor,
that's an injury.
Harmful. It's
If that's
injurious.
an injury, anything's an injury. And I think that's why the Supreme Court did ultimately, by what looks like a 7-2 vote, step in. And I think this is another instance where the court is saying, slow your roll, we're not there yet. But it's becoming a hot war between these district court judges who are nuts, who have no pretense of being real jurists, who are ideologues and partisans in robes when they remember to put them on, who do not even bother to write in the language of judicial opinions. that they are not heeding the court's warnings. They are going full throttle. And so the court's going to have to decide if it wants to step in and stop this judge shopping.
Mario.
I also just think Article 3 standing is not enjoying its sort of highest moment in front of, they don't seem to be taking it seriously in a number of cases. They sort of, there's a standard, most typically it's from Lujan, a case where you're supposed to have, an injury in fact connected to the government that produces a redressable injury. And there seem to be in these cases that lots of these groups fail on one of these vectors. And SFFA, which we'll talk about later, was actually the membership group has no members. Does that mean that there really is a problem? Biden versus Nebraska today, should the states have standing? There was this robust argument among jurists that really there was no injury to the states from the loan forgiveness, but the court said at least Missouri has articulated, and it's mostly because, and I hate to say this because I don't like to say it in front of my students.
I'll say it.
It seems to be something that, a kind of question they answer consistent with whether they want to hear the case or not, and when they, I've just made the argument they all want to make in class, but I reject. So if they want to hear the case, then they poo-poo or sort of the extent of the injury isn't important. Things like whether the membership group has members, things like the group itself is an artifice put together, seem to be less important.
All right, so what I want to do is just take a moment before we get to even more hot-buttoned issues, including the affirmative action case from yesterday and others, which is to just spend a moment on ethics and the court.
Oh
right?
My. This is not a good moment.
It's right, where to begin, boarding schools being paid off by donors, mothers having homes purchased and fancy trips.
It was the auntie, I think.
It was the auntie. Auntie got a house? I thought it was mama got a house. Okay,
auntie.
all right. But there are many people who are concerned about the Supreme Court, its trustworthiness, whether it reflects the American population. One could certainly say that it is a group of elites, even if we weren't talking about these cases, right? It is a group of people who, for the most part, have graduated from basically 2 law schools. Yeah. Amy Coney Barrett presents, an alternative to that, but that's just one of the justices. It's a court that, in its over 233-year history, has not been very diverse. Only recently has had its first black woman that has now been confirmed to the court, Justice Ketanji Brown Jackson, who just is concluding her first term. But all of that said, it has the lowest approval rating that it ever has, since there have been polls about how Americans understand the court. Your thoughts about the court, ethics, et cetera, from Alito to Thomas, et cetera. Who wants to begin? Jamelle, why don't you begin?
Yeah.
Yes.
So, how do I put this judiciously? The court, there's strong evidence to suggest that the court is incredibly corrupt.
That's how you put it, I guess.
That is not where I thought you were going.
He paused, though, for selecting his words.
When it comes, we know the details, right? That Clarence Thomas has essentially this sort of billionaire patron friend who provides very fancy gifts and vacations to him. Sam Alito has been the recipient of some of this. Justice Scalia, when he was on the court, was the recipient of various forms of largesse, hunting trips, lodges, that sort of thing. This has been part of, at least, and that's that part of this ideological wing of the court, part of their behavior is readily and without any sense of any lack of propriety or anything, just taking gifts from wealthy people. I myself have a few theories about what's going on here, and I mostly see it as an attempt to ensure that the conservative justices, and particularly the ones that are coming very much out of the conservative legal movement, do not begin to take their independence too seriously, and connecting the justices to awards and dinners and trips and gifts and all this stuff isn't so much to get them to rule a certain way necessarily, but to create strong social ties with the conservative legal movement and ensure that what they're worried about is not so much the public opinion or not so much sort of mainstream political world, but the esteem of their peers within the movement.
It seems that what you're suggesting is that the power behind it is pillow talk.
Right, right,
right? It's about doing the soft part
right, right.
that ultimately carries.
This is an interesting point. It's one that's been made repeatedly by Corey Robin, who's a very interesting biographer of Clarence Thomas and an observer of the court. He says that, you know, it's not necessarily corruption in terms of just straight quid pro quo. Like, I will take you on this very fancy fishing trip in Alaska in exchange for this kind of ruling where I have interest before the court, although, you know, there is an appearance of that happening, but that's not necessary for corruption to be there. What there is sort of a density of social ties, a sort of surrounding of influence and suggestion and connections to these interests that doesn't need to be as crass as you know, a sack of cash with a dollar
sack of
sign on it.
coins.
Yeah.
The problem is it's patently unfair. I was a former government attorney. I was in the Navy JAG Corps for more than 20 years. As a government attorney, you have the Office of Government Ethics, Standards of Conduct, which limit the gifts you can take, the amounts. They're highly regulated. You can be prosecuted if you violate it. Federal judges, lower than the Supreme Court, have ethical standards, which they have. The fact that the court itself sort of is without any sort of standards which limit you know, ethics is a problem, mostly because of what Moira mentions, which is, I agree, I don't know that there necessarily is any sort of quid pro quo, but what you're regulating is the appearance of impropriety, because what happens is it undermines the legitimacy of the court with the public.
I mean, well, truth be told, law students are held to a standard.
A higher standard.
A higher, no, seriously, I mean, they are, right? I mean, before they can even take the bar exam, their character and fitness has to be assessed. And that is assessed at the law. There are many things that they cannot do where they may not sit for the bar. And so when you say it is a higher standard, that's not hyperbole at all.
It is a standard.
It is a standard. There is a standard. Mark, I don't know if you wanted to add anything to that before
I mean, just
we move
briefly,
on.
it's like they can take all the private jet trips they want. They can go on all the fishing trips they want. They can travel around the world. All they have to do is disclose it. That's all that
But there hasn't even been the disclosures.
And they refuse to disclose it. And when called on this, and we saw this from Justice Alito, they act so aggrieved. How dare you question my conduct, right? Justice Alito, knowing that there was going to be an expose about him, published a pre-buttal in the Wall Street Journal saying the lodge may have been very expensive, but to me it was rustic. And you know, we may have had some wine, but I've had $1,000 wine before, and that wasn't it.
This is no screaming eagle.
Yeah, I mean, it's ridiculous, and I just want to tie this to like the broader point. Only recently have SCOTUS reporters started reporting on these guys like public servants who deserve scrutiny. Yes. For decades, they have been able to operate totally above suspicion. They are so unprepared to handle that scrutiny, and that is only just becoming clear, and it's going to be a huge problem for them moving forward.
Can I add, just to tie this to maybe like a larger structural observation about the court, which is that, you know, one of the hallmarks of the modern political order in the United States is the court is understood to be kind of the exclusive interpreter of the Constitution. This is unusual historically, right? The FDR's court packing scheme was as much a claim of FDR saying, I think the executive branch has a right to say what the Constitution means, as it was an attempt to get a favorable court. And you can look back to Lincoln, to Jefferson, to Jackson, right? You can look at presidents and Congresses pushing back at the court's interpretation of the Constitution. But for the past 50 years, the general consensus has been the court is where it has the final say. And I think what has happened is that the court itself has begun to see itself as essentially above the constitutional system, right? It's existing not simply as one of three branches that can be checked and limited by the others, but as like a super branch that controls the conduct of the other.
Well, this is, Jamelle, I think you're pointing out something very true that's relevant to the conduct of the court over the past few terms especially, is that the court is really taking advantage of the gridlock in Congress and the impotence of the legislative branch to check it. Like corruption stories that have come out, and I think, we would be remiss if we did not credit the excellent reporting of ProPublica, who have done an
Incredible
amazing
reporting.
job.
Absolutely.
But this has not been met with silence from the Judiciary Committee. It's been met with a Judiciary Committee that is incapable of doing very much. It doesn't have the votes to issue a subpoena. It doesn't have the ability to say anything beyond, like, pretty please, John Roberts, will you come testify? Pretty please, Harlan Crow, will you come testify? And they get these letters back telling them to kick rocks. And that's because Congress is weak, that the judicial branch has both colonized a lot of policymaking power and also become, indifferent to the efforts to check its really reckless expansion of its own prerogatives.
Well, there's so much more that we could unpack clearly on this note, which I think is critically important, and it brings me to thinking about January 6th, where we won't go there, but all of that, truly. But let's turn to affirmative action, right? Students for fair admission. Yesterday, the Supreme Court ruling 6-3 in one of the cases, the North Carolina case, because Justice Ketanji Brown Jackson could participate in that. She recused herself from the case that involved Harvard, where it was 7-2. And so let's see, Mark, why don't we begin with you in terms of that case?
Well, the Supreme Court said racism is over. And per Jamelle's observation, the other branches have no choice but to nod along. I'm oversimplifying, but what the court did through Chief Justice Roberts' majority opinion was essentially ratchet up the scrutiny that's given to affirmative action programs so much that no program as it currently exists can continue to operate, which is really, I think, a catch-22, because what the court has done here over the last 50 years is say, you can't have quotas, you can't have any kind of measurable standard for building out diversity. All you can do is look at students holistically and try to use race as one of many factors. And in this decision, Roberts scolds Harvard and UNC for not having any manageable way of measuring race and diversity in the class. And that's because the court said it couldn't do that.
Yeah.
They would have gladly done it, but the court says no.
Mario.
Okay, so I want to say, when I first read it, I was expecting it, but it did put me in a position of saying, what are colleges and universities supposed to do where they do believe there is an educational value in diversity? Race is one of the things we think is important.
And former dean of a law school. Yes.
And a state like California, where under the state constitution, you're not allowed to consider race as a factor. And so my sentence was to try to look at it and said, what remains of affirmative action, if anything? Because for those of us who were hopeful that after Fisher, this would be another tweak rather than taking the bulldozer to it, what you would have done is to say, well, on the standard of you must have a compelling interest and narrowly tailor it, that they would have tweaked narrow tailoring, saying these plans have problems, but that, moving forward, diversity is still a compelling interest. The problem is they completely undermined the compelling interest standards by saying there were no measurable standards. There were problems between the means selected by the schools and the goals themselves. Then they resurrected all of this dicta from cases that we had never thought was controlling to add, now you can't use race in any way that negatives any other applicant. You must have an absolute sort of date certain for ending if you want to have. So there were all these things that had been mentioned in various ways that now seem to have been elevated, but the saving grace, if we have one, and maybe you can tell me if you agree, Jessica, is they didn't out and out overrule Fisher. They actually qualified Fisher. Fisher was not justified on the same justification that Harvard and UNC, training.
And say just a little bit about the Texas Fisher case.
So that was a case in which it was the law school, the Texas was using race measures that they said it was a critical mass that they were trying to achieve. Now, they didn't use any really measurable standards to define critical mass, but they didn't say it was to train leaders for the diverse world.
Right.
And so there, with Justice Kennedy being the fourth vote in favor because it was a 4-3 case, they said the way in which Texas had sort of exhausted every other way to create diversity, but the consideration of race as one among many factors in this was justified based on the critical mass. And what the Justice Roberts actually says is we are not saying that the Fisher case, which considered the critical mass, is at this point overruled. And so my sense is, however, the problem is, but if you come back with and argue critical mass, will you be held to this standard of now it has to be a measurable, defined standard? Because what Justice Kennedy liked about it was that it didn't create a quotient of how much race was enough.
But something that I want to get to, and then let's talk about the dissent. Dissents, both Justice Sotomayor and then also Justice Ketanji Brown Jackson, because the conversation about affirmative action gets conflated, it gets diluted, many different things, right? And the reality is that Justice Thurgood Marshall, when he was a student, would not have been admitted to the University of Maryland because the University of Maryland discriminated against Black people being able to gain admission. Sort of the history before affirmative action was blatant state-enforced discrimination, right? And it's a part of our history that we don't pay attention to. Pauli Murray, who in many ways really preceded and laid the ground for Ruth Bader Ginsburg, including at the ACLU. She graduated first in her class from Howard. She went to Howard, a historically Black law school, because racial discrimination at America's schools. She graduated first in her class. And of the work that she did there as a student, one of her papers was used in the arguing of Brown v. Board of Education. In 1945, in the California Law Review, she published an article about sex discrimination against women in employment. Pauli Murray was a badass, but one that probably nobody's heard of because she was a Black woman. And she was at the ACLU long before Ruth Bader Ginsburg was, and left her files and her notes. So the things that we come to think about today of, oh, Ruth Bader Ginsburg, oh, Pauli Murray, who had left all of this before. And Pauli Murray had also had a scholarship from Harvard that was withdrawn from her because it was discovered that she was a woman. So on both counts, being Black and a woman, having experienced such tremendous discrimination, but whose work served as such a foundation for how we understood the arc towards justice with regard to sex equality and also racial justice. But the reason why I mentioned Pauli Murray as sort of setting the tone for then thinking about the dissent is that Pauli Murray leaves behind for us, she died long ago, but she leaves behind for us a book called Race Laws in America. It's about 800 pages, single space, about all of the racially discriminatory laws in the United States. If you're Black, you can't go into the park. If you're Black, you may not play checkers in public. If you're Black, you may not go to the bowling alley. If you're Black, you may not go into the front of the restaurant. If you're Black, you may not be in the taxi. This was America, not in 1872. This was America in 1952, 1962. And so then when we think about affirmative action, and I think that part of it is that many people think, my child has a 4.3 GPA. These people getting admitted must be people who are deeply illiterate with maybe a second grade capacity for reading and writing, and not understanding that those foundations were explicit racial discrimination such that a Pauli Murray, a Thurgood Marshall would not gain admission. So let's turn to the dissents. Who wants to start? I'm looking at you, Jessica.
I thought Justice Jackson's dissent very beautifully made the argument that racism is systemic, pervasive, institutional, and historical, and there is a deep disagreement on the court about what race means, what racism means, and what remedies are appropriate. And we see that illustrated.
Well, you see that tension too between Justices Brown Jackson and Justice Thomas.
Yeah.
I mean, it was as if
They
I was thinking,
each other in
thinking like switchblades. This is like West Side Story. Justice Thomas, it just seemed to really go after her in many ways. It's like, oh, he pulled out a legal switchblade.
Never before has Justice Thomas served with another black justice who is able to step up and defend affirmative action. And I think he was...
Or anything, or speak to racial history as a general matter.
Right.
This is what I think is so significant about Thomas's concurrence, and the real sense in which he was going after Brown Jackson, because Thomas has grown accustomed over 30 years to basically be able to say,
He's been able to make stuff up.
I'm going to represent the black perspective here. I'm going to represent this particular history. And Brown Jackson has consistently said that you are misrepresenting the history.
Yeah.
You are misrepresenting. I just want to give an
Yes.
example of this. In his concurrence, he says, he pushes back against the notion that the Reconstruction Congresses were using race in their policy making by saying, well, the Freedmen's Bureau...
You can't make that up.
He said the Freedmen's Bureau wasn't a reference to black people, it was a reference to former slaves. Freedmen weren't necessarily black, QED. But I mean, first, that's like absurd on its face. But also, the Reconstruction Congresses, one of the first bills that come out of this Congress is the Civil Rights Act of 1866, which is explicitly using race to attempt to ameliorate, in particular, laws called black codes, right?
Yes.
that the black codes did not apply to freed people. They applied to black people in the states.
Well, in fact, just with a little bit of that history, right? Because this is a Supreme Court that has said that it is invested in history and originalism. And I think in part what Justice Brown Jackson is doing is saying how I read history and how you read history is completely different. Right? Because I read history as the 13th Amendment abolished slavery and involuntary servitude. And that involved black people.
Right.
And of course, if you read the legislative record and debates, it's all very explicit. As the South is saying, no, those people are our property, and we get to keep our property, right? It's very explicit. The 14th Amendment as well, and she's calling that out.
Right.
I was really struck
Okay,
by
Jessica, and then Mario, yes.
how the majority opinion in recounting the history that led to Brown
Never said slavery.
mentions slavery. It's a shocking way that they describe that history as almost colorblind as the principle that someone is not
this is what they
based
do.
on racial
Right.
stereotypes. It's bizarre.
So I want to speak across the dissents, right? So I actually think it is Sotomayor, which is the opinion that takes on both the majority and Thomas in sort of their reinvented and rewritten history, including the Reconstruction Congress, the statutes that followed, and what they meant to the consideration of race consciousness.
Explicitly.
But it's what Justice Brown Jackson does, what I love, is build from that into our contemporary moment of how race matters now. And she looks at every sort of meaningful condition of life, health, wealth, education, and traces racial gaps, and then traces them back.
And he says that that is meaningless in
he
his
says
concurrence.
It's meaningless, and she's hooked on victimhood.
Yes.
And she says, too many straw men to deal with, Justice Thomas.
And he's also skeptical of this idea of systemic racism, thinking it's almost an insult to people like Thurgood Marshall.
Well, let me
You can
just
never
say-
achieve as a person of color if systemic racism.
Okay,
Yes.
this is something I make a point too
Yes.
about the scope of this ruling. I think the majority opinion is deeply confused on what race means. So this Freedmen Bureau's example, what does it, is that the same thing as race to identify freedmen? And then at the end of the opinion, the Chief Justice says, well, Harvard and UNC can't do what they're doing, but of course you could consider an applicant's race if the applicant themselves brings it up.
As overcoming, as a description of overcoming
But don't
adversity.
take it too seriously in their personal statement.
How is this different than what Harvard and UNC were doing before is a point Justice Sotomayor
I'm going to get
makes.
Maura in here. Maura, you had something to say about
I'm
this.
sorry, I just want to point out something that's been pissing me off. and that, Mario and Jessica also touched on is that the majority opinion, and to a degree also Thomas's concurrence, they try and take the story of racial progress, that they always begin the story with Plessy and end it with Brown. And they try to take the moral authority of the black struggle, but divest it of any kind of moral content, right? And Thomas does this all the time. He's like, it is a story of removing racial considerations from our law towards this ideal of what Roberts calls the colorblind Constitution. And that's completely ahistorical, which is one of the reasons I'm really glad to have Jackson on there, because what the court has sort of commanded that these schools do is abandon what is the best argument for affirmative action, which is to remediate historical injustice, right? They've said that you're not allowed to have a remedial argument that says, we are going to shape our classes this way because our past has been something dishonorable and we want to be an agent of change. And so, Jackson, I'm really grateful for her dissent because she kind of rehabilitates the rehabilitative argument. Says, this is actually a historical trend of being very race conscious and being conscious of history and using the law affirmatively, as even President Johnson said, to try and undo that history.
Well, to the point that was made that now Justice Thomas cannot stand alone with with how he has articulated about the experiences of Black people, I think many will find to be refreshing. Let me just say that it also seems as with Justice Thomas, to the extent that race matters, it matters about his own life. If you think about the Dobbs decision, for example, when he says that all of these other areas of privacy, I'm happy to see the court deal with them and kick them down the curb, with the exception of interracial marriage. He and Ginny should not be affected.
Leave us alone.
In the Bruin decision, just the day before that, so in Dobbs, you will not find any sort of record of there needing to be a prologue related to women. In fact, women aren't mentioned. You will not find in all of the Dobbs decision these two words, Black woman or Black women, at all in the entirety of the decision. But the day before in Bruin, Justice Thomas says a prologue is necessary. A prologue is necessary to understand the plight of Black men historically when they have not been able to own guns. And he spends 5 paragraphs talking about Black men whom I think that he might see some sort of likeness to. A Black man who is a music teacher, a Black man who is a professor in mathematics, that kind of thing. He's not afraid to go there in history and reflect about what might have been himself in history, but certainly not others. But we have to move on because time is coming to a close and it's been too quick. All right, so I want to get to the Indian child welfare case. So Jessica.
So this case, Holland versus Brackeen, involves a challenge to the constitutionality of the Indian Child Welfare Act, which was a statute passed by Congress in 1978 to address a horrible situation, the widespread removal of Indian children from their families to non-Indian families. And what ICWA does is it sets up some procedural safeguards to get in the way of the removal of an Indian child. It gives tribes some voice in those adoption decisions, and it sets out a scheme of preferences for who can adopt Indian children with Indian families first. Now, this case was a challenge brought by a couple different sets of potential adoptive parents, including Chad and Jennifer Brackeen, who wanted to adopt another Indian child. A plaintiff was also a birth mother in the state of Texas. The Supreme Court surprised everyone by upholding ICWA by a vote of 7-2 in an opinion written by Amy Coney Barrett, who herself is an adoptive mother. The court said that the Constitution gives Congress the power to regulate Indian affairs in this way, gave Congress the power to pass ICWA. One interesting thing about this is that the majority kind of found that power not in any specific textual provision, which is unlike Dobbs, where they said, well, we don't find this right to abortion in any specific textual provision. But here, not having a specific textual hook doesn't matter. They said Congress does have the power to pass ICWA. And then importantly, they held that the plaintiffs didn't have standing to argue that ICWA was race discrimination. which is great because this case represented a threat to all of federal Indian law. If federal Indian law was characterized as race discrimination rather than protecting the political sovereignty of tribes, it would be disastrous. And so commentators were very excited by the result in this case.
I'll add the one other point for con law scholars is there was a point about something we call an anti-commandeering principle, right?
Right.
So anti-commandeering is a sort of 10th Amendment principle that suggests the federal government cannot conscript states into a federal regulatory scheme. So, right, the federal government, if you want the states to do something, you have to incentivize them, you have to invite them as part. You're not allowed to pass a law that then requires the states through their mechanisms to essentially help you achieve the federal purpose. And the claim was ICWA did this to state adoption agencies. And the court had been in a series of cases, Prince, New York, Murphy, had been very hostile to the federal government statutes, which seemed to create any requirement. But here, it was interesting. They were sort of the mind that the requirements that were created for states through ICWA were ancillary, and that they governed states in the same way they would sort of govern private entities, which is from a case called Reno versus Condon, right? And so my sense was, but that's not what we've been seeing. So this was a bit of a surprise in their commitments to easing off on their pro-state sort of sovereignty 10th Amendment positions. Now, you will not be surprised that Justice Thomas wrote in Dissent to hold up the very point you raised, which is there is no explicit Article I power that authorizes ICWA, so it should be deemed unconstitutional. So.
Is this, I wonder, and then we really quickly will do two last cases and say thank you to our audience. Would any of you say that this is Justice Thomas's court now?
Ooh.
I know his clerks like to call him the real Chief Justice.
Ooh.
Ooh.
I'm just going to go out on a limb and say I would not say that. I would emphatically reject that idea.
Yeah. I would both reject it, but also say to the extent that the court operates without any real regard to any broader principle other than like the exercise of its own power, that strikes me as like very reminiscent of just like Thomas's whole deal.
Mm-hmm. I can't say it's his court because he's most known for articulating over and over very narrow and extreme positions, right? He doesn't typically write in the majority.
But has he had influence? It's an interesting thing. So when our daughter was about 9 years old, I took her to hear Supreme Court arguments.
Poor baby.
But the interesting thing, as we were sitting there, she leaned over and she asked me, she said, "Mommy, why does it look like the black judge, he looks asleep?" And he did look asleep. And I have to say that in these times, Justice Thomas is awake. He's not woke, but he is awake.
He's barely more verbal.
Okay, all right. Very quickly, today we had a ruling about the president, Joe Biden, and the debt relief for students from their college debt. Again, 6-3, Department of Education v. Brown, Biden v. Nebraska. Who wants to quickly take that before we close out?
I'll give the quick facts. The quick facts was this was his attempt to use something called the HEROES Act from 2003, which allows the president and Department of Education to make, in times of emergency, certain modifications to student financial arrangements. And the real question was whether, first of all, there was standing to bring the case by states who brought it in Biden versus Nebraska. And the court found, with not a lot of meat on the bones, that there was an injury at least to Missouri. The second question was, did the secretary and the president have the power to cancel the debt? And the court found no on a theory of basically statutory interpretation, which says that canceling debt, that $430 billion in debt, was neither a waiver nor a modification within the meaning of the language of the statute because it was too transformative.
How do you reconcile the ruling today with the affirmative action ruling? I mean, it seems almost that, can one say that this is a court that has abandoned any kind of knowledge of people deserving to be educated? what do you make? I mean, can you see any thread? Do you see any thread between the affirmative action case and the student debt loan?
I would say the court does it, right? It would put one squarely in the bucket of presidential power, executive power, and the other within equal protection and sort of understandings of the limits of considerations of race.
The thread I perceive in the two cases is more that in each one it's the court taking a very outsized role in deciding what any sort of other actors in the society can do, right? In the case of the student loans, the court's saying, we don't like the vibe of this, so you can't do it. And with affirmative action, it's like, we also don't like the vibe of this. If you do it in this very particular way that we're not gonna really, exactly articulate what it looks like, but if you do it that way, then we might be okay with it, but otherwise we're not. And in both cases, it's not really any clear rule, any real clear thing that policymakers, elected officials can follow. It's just the court's discretion. And it's the court claiming large amounts of discretion for itself.
Yeah, I was reminded of Trump versus Hawaii, where they say the statute says what it says. The president has the discretion to make this determination in the interest of national security about, banning, sort of which visa. And here it's like, no, those words mean something very particular. And, this is not waiver or modification.
It's a court that then is opportunistic, perhaps, in some of its rulings that we've seen in recent years.
There's grumble from the crowd.
Okay, last case. And really, there could be so more. And aren't they fabulous? Can we just give it up for Jamelle, Jessica, Mark, Mario, Moira, Groff v. DeJoy. It's a unanimous decision. Mark, what's happening there?
I would love to know. Reading this decision was an incredibly surreal experience to me because it was written by Justice Alito and it was incredibly reasonable, which those are not two things that ever go together. But this was a case about when a religious accommodation required by Title VII of the Civil Rights Act in a workplace imposes an undue hardship on the workplace such that they can say no. And there's been a huge amount of confusion in this area because many years ago the court said in sloppy language, if it's anything more than a de minimis burden, then the employer can just say, I'm not doing it, which has led to truly atrocious rulings on the lower court. Rulings saying customers don't like Muslims, so we're not going to hire Muslims, and courts say thumbs up. Customers don't like Sikhs, so we're not going to hire Sikhs. There was a brief filed by religious minorities in this case saying, just FYI, we know that there's a lot of Christian nationalism in these religious liberty cases, but this one's different, and we really need some clarity here, and that's what Justice Alito provided. He really did say, I think quite coherently, that it's not just de minimis, that you can't rely on the bigotries of customers or other employees or managers, that you have to carefully measure a truly undue hardship, and that if you can't prove it in some way, that the religious accommodation must be granted. And again, props to Sam Alito. He must have had $1,000 wine the night before he wrote that opinion, because it's probably the best thing he's ever produced.
Wow.
That's high praise.
With that, will you all join me in thanking this incredible panel for our 2023 Supreme Court term in review. Much more that we could have discussed, and I want to welcome H. Adam Harris back to the stage.
Thank you all so much for joining us for the 13th Annual Supreme Court Term in Review. One more round of applause for Professor Michele Goodwin and her guests. We welcome you to join us in the lobby for some refreshments, some book signings. We're thrilled to see you. Thank you for being here. Hope is the way forward. Be well.
Hope. I hope we get some new justice.